We are here today to call for an end to impunity for human rights violations by security forces in Jammu and Kashmir. In 4 days, that is 5th of July, it will be 25 years since Armed Forces Special Force Act was deemed to have come into force in J&K. In this time, there have been many abuses by security forces, yet not a single soldier has put trial in a civilian court in all these years. The report that we just released documents several accounts of grief and loss. As an established policy, Amnesty International does not take positions on the legitimacy of the territorial claims made over any part of Kashmir. We do not take position for or against self-determination calls made by any group. We are also not commenting on the military decisions that are taken in relation to the troops deployment or withdrawal. Our concern mainly in this report is to really look at the affected families and their right to justice. That's the core thing that we are really looking at in this report. We recognize that there have been several abuses by armed groups in the state, including against Kashmiri Pandits. We have consistently opposed all such instances, including one of the statements that we brought out in relation to the incidents of attack on civilians in Sopore on 25th of May. And there are many more stories of this nature in the flash drive that Durga highlighted, that you can really look at some of our statements that have come up. We are also very strongly expressing our concern about whether recent steps that have been taken to rehabilitate Kashmiri Pandit families in the state, whether these families would be provided with adequate remedy and reparation. We are also expressing our concern in that area. We must recognize that recently, Army has shown some signs of commitment to ensuring justice. The convictions in the Machil fake encounter case and the prompt investigation into the case of the Badgaon shooting are the welcoming measures. We welcome these measures. But the government needs to do much more. And it can start by repealing the Armed Forces Special Powers Act. Interestingly, it will be important to note that this act, in its originality, was promulgated in 1942 by the British to quell the Quit India movement. So it's important to see the legacy of this act, which goes beyond the independence and is part of the struggle for independence. In Jammu and Kashmir, it was introduced as an emergency measure in 1990 to combat the violence by armed groups, but instead it has contributed to increase alienation, anger, and cynicism in the state. Our research on FSPA is part of our global work. So this is not only focused on India. It is part of our global work that we do. We have brought out reports in relation to the excessive use of police force, whether in case of Baltimore in the United States or in case of protests in Hong Kong. We have also actually brought out reports which are linked with the impunity enjoyed by the Shia militia and the abuses by the Islamic State. In Pakistan, we have examined the lack of accountability for armed forces who commit human rights violations in the tribal areas. So we've done all this work as part of our total work against impunity by the security forces all over in different parts of the world. India's own constitution guarantees the right to equality and justice. Many in Jammu and Kashmir have had neither for decades. The government of Prime Minister Narendra Modi at the center, the government of Chief Minister Mufti Mohammad Saeed at the state have a historic opportunity to correct the decades of injustice by working to repeal the FSPA. This law has no place in civilized society, and it's time for it to go. Thank you very much. May I now request Divya Iyer, who is a research manager at Amnesty International India, to take you through the key findings of this report. Divya.
Thank you, Manal. Good evening, all of you. Let me start by thanking people without whose generosity insight and support, this report would not have been possible. We are grateful to Parvez Imroz, Khurram Parvez and other staff of the Jammu and Kashmir Coalition for Civil Society, Karina Ahangar, Zahur Bani and other staff members of the Association of Parents of Disappeared Persons, the lawyers of the Jammu and Kashmir High Court Bar Council, our translators and drivers on the field, and many more. But most of all, I would like to thank all the families who opened their hearts and homes to us, shared their stories of loss, grief, sometimes thankfully hope, and trusted us to tell their stories in their quest for justice. Amnesty International has done a lot of work in Jammu and Kashmir in the 1990s. Our research repeatedly uncovered patterns of impunity in the state. Then in 2002, we wrote to the then Chief Minister Mufti Mohammad Saeed, raising concerns about impunity that special divisions of the police enjoyed. And today, in 2015, we are presenting to you a report about families that continue to find and face obstacles in justice, both in law and in practice. Over 2.5 decades later, justice and closure to these families is still denied. And that is the most worrying finding of this research. Our research team in writing this report interviewed over 58 families in various districts of Jammu and Kashmir, analyzed government and legal documents related to over 100 cases of human rights violations from 1990 to 2013, specifically cases which had a request for sanction to prosecute. We also filed right to information appeals, including to the Jammu and Kashmir State Home Department, Ministry of Home Affairs and Ministry of Defense in Delhi, and to all the paramilitary forces in India. While most departments did not reply, the ones who did denied us the information. Our research team also interviewed lawyers, government stakeholders, different civil society actors in both the state and center. There are quite a few key findings and recommendations of the report, and the primary one relates to Section 7 of the Armed Forces Special Powers Act 1990. Now, this particular provision, which gives effective immunity to security forces from prosecution, mandates that an executive permission is required from the central ministries, Ministry of Home Affairs and Ministry of Defense, before a soldier who is accused of a human rights violation can be prosecuted in court. Now, this is not when a soldier is merely suspected of a rights violation, but after the police has established charges, after going through a criminal investigation, that this provision actually comes into play. But at that time, Section 7 of the ASPA actually prevents the prosecution from going forward without an express permission from the Ministry of Home Affairs or Ministry of Defense in New Delhi. And to date, what is worrying is that not a single case has been known to be granted this permission or sanction to prosecute. In fact, in February this year, the Defense Minister admitted on the floor of the Rajya Sabha that at least 6 requests from Jammu and Kashmir for sanction to prosecute are pending as of today, with one case pending since 19